Good afternoon, everyone. We're going to call the meeting for Regulated Industries to order. Members, if you need any could you please call the roll? Okay. Sorry.
Chair Stargell?
Here.
Senator Brannan?
Here.
Senator Dietert?
Here.
Senator Flores? Senator Galvano? Senator Gibson?
Here.
Senator Legg?
Here.
Senator Sachs? Senator Sobel? Senator Thrasher?
Here.
Quorum's present, Madam Chair.
Thank you. And we do have a couple members that are going to have to come and go, so we're going to try to proceed as quickly as we can and also try to watch a quorum at the same time. So, members, if you need any help with the electronics, we have people here who can help you. Senator Sachs has been excused from the meeting today. If you plan to speak on a bill, please fill out an appearance card, and please remember to turn off your electronic devices. Okay. Welcome, Senator Negron. We appreciate the run from the Knott building, and you seem to be evidently much more fit than I am because I would be dying at this point. But you are recognized to discuss Senate Bill 286 on design professionals.
And thank you, Madam Chair, and I apologize for any inconvenience I caused to you or committee members. We just had our public right to speak bill up, so thank you for your graciousness and allowing us to have a little extra time to get here. This bill really does one simple thing. I believe in people having a right to their day in court when they believe that they've been wronged by another person. I've generally been leery of measures that take away someone's right to have access to seek compensation or other measures if they've been aggrieved. That's why we have juries. That's why we have the courthouse, and I want the keys to be open to everybody. But I say this as someone who's practiced for many years. I do think that it's an abusive practice when a person has a claim against a company or a firm, and instead of pursuing just that claim, they then bring an individual claim against either an employee or against someone in their individual capacity, when in reality that's not where the recovery is going to come from, because the liability insurance is almost always with the company. So all this bill doesn't have caps on damages, doesn't take away anybody's claims. In fact, if you don't want to participate, you don't have to. All it says is that when you make a contract with the design professional, if you contract with the firm or the company or the business entity or the organization, that you can have a provision in the contract. Again, the word can, not must. You can have a provision in the contract. It has to be at least 5 points bigger than everything else. It has to be in bold. And it simply says that your contract is with that particular firm and not with an individual. Let's use an architect, for example. An architect would have to be acting in the course and scope of their employment. The architect would also not in any way have damages limited against the company with regard to negligence, with regard to anything with a third party. It would strictly be a negotiation between the two parties that it would affect the economic damages. And if there was a requirement in the contract, which frequently there is, that a certain amount of insurance had to be available, because many of you may know more about the construction industry than I do, but in the construction industry, everyone's concerned about getting sued if things go wrong. So the majority of contracts in the construction industry between design professionals and general contractors and owners have requirements for insurance, because the contractor wants to know, if I get sued, the engineer's probably going to get sued, and we want there to be coverage. So importantly, if the contract said there had to be malpractice insurance, this provision doesn't apply if there's not malpractice insurance. I would argue that this bill actually gives heightened ability for recovery to claimants by having incentives for design professionals to have insurance. So we're taking away no one's rights. We're simply saying, if you have a contract with an architectural firm and they make a mistake, sue the architectural firm. But don't go suing people in their individual capacity when they were in the course and scope of their employment. That explains the bill.
Thank you, Senator Negron. And also there is a one late filed amendment. If there's no objection, it's a courtesy amendment by Senator Thrasher. So, okay, having withdrawn that amendment. Okay, are there any questions of the sponsor? Okay, seeing none. There are several appearance cards. So I'll just start going through them. If any of you would feel inclined to waive in support or in opposition, that would be wonderful. The first one up is Frank Riddell. from the Contract Design Professionals.
Frank Rober, the Florida Engineering Society. We got about 40 engineers in the room. Just want to say thank you and wave your support.
Waves in support. Okay, Joe Adams. You recognize?
Good afternoon, ladies and gentlemen. My name is Joe Adams. I'm an attorney. I practiced law in Naples and Fort Myers, Florida for the past 28 years. My primary practice these days is representing condominium and homeowner associations, and I do handle other types of cases. With due respect to Senator Negron, I believe that this bill constitutes a radical departure from existing Florida law and the consumer protections that are found therein. I would draw your attention to a 1999 Florida Supreme Court case called Morance versus Heathman, where Philip Morance contracted with an engineering company for the inspection of his home. When it turned out that the home was not as held, he sued the engineer that did the inspection. And the Florida Supreme Court held that the engineer should be held liable based on long-standing principles of Florida law. I'm going to read you what the court said. Under Florida law, a person who is injured by another's negligence may maintain an action against the other person based on the person's violation of duty. Further, where the negligent party is a professional, the law imposes a duty to perform the requested services in accordance with the standard of care used by similar professionals. The duty of a professional who renders services, such as a doctor, a lawyer, or an engineer, is different from the duty of one who renders manual services or delivers a product. That's governed by contract. The duty imposed on professionals is to perform services in accordance with the standard of care used by similar professionals. And I submit what this bill would do would not hurt big contractors and big companies that have the resources to bargain for the allocation of risk. It will hurt small people, individuals, and small businesses who are going to sign the form contracts that are presented to them, which will be drafted by industry representatives doing their job, and they will provide essentially no recovery in cases where shell corporations are set up to avoid liability. I had substantial experience after Hurricanes Charlie and Wilma in representing people with very substantial needs for design assistance, and in many cases with people that really shouldn't have been doing it. I submit to you that having the person responsible for doing this work, just like a doctor or a lawyer should be, is the more proper public policy, and so we're opposed to the bill. Thank you.
Thank you for your testimony. Andrew Cummings.
Wave in support.
Waves in support. Chris Laurie.
Wave in support.
He waves in support. Warren Husband. Thank you, sir. You're recognized.
Thank you, Madam Chair. Senators, my name is Warren Husband. I'm with the firm of Metz Husband and Daughton here in town. We represent Associated General Contractors. And regrettably, we do oppose the bill in its current form for some of the reasons mentioned, but I'll just tick off three kind of broad policy questions that the bill kind of poses for you. The first is, as was touched on, as a professional like a doctor, a lawyer, an architect, or an engineer under the current law, you can't insulate yourself from personal liability if you commit some kind of malpractice in the scope of your profession. Now, this bill would single out architects and engineers and allow them to insulate themselves contractually from a certain subset of liability. And I think the question to be posed is, why should architects and engineers have that capacity when other professionals do not? A second issue that I think you need to think about is that really, whenever there's an injury, whether it's a personal injury, an injury to a problem with the property itself, one that may affect neighboring property owners, it's really ultimately about the insurance. Who has insurance and what does it cover? And if a structure fails, you're going to have potentially the property owner who's impacted, adjoining property owners, and someone who may have been injured by the defect, the construction defect, whatever it might be. And all those folks are looking to where the insurance is to be able to make them whole. But there are a number of architects and engineers who actually go bare. They don't have any coverage. And in fact, there's lots of others who have very minimal coverage in terms of their policy limits. And what we suggest to you is that if this bill allows contractually an architect or engineer to shrink that potential liability even more with respect to the owner, that frankly encourages even more folks to go bare or to have their limits reduced even further, which means that injured parties, third parties with damage, have less of a pool of insurance to go after to try to redress their injuries. And lastly, while the current bill premises the elimination of individual liability on the property owner contracting away in an agreement with the design firm this kind of liability, I mean, can we really expect, as was touched on, homeowners or even small business owners to really be able to appreciate the types of liability and insurance protections they're negotiating away when they sign one of these agreements? So again, regrettably, we have to oppose the bill at this time, but if it moves forward, we hope to work on that and some technical issues that others may address where we think it doesn't necessarily line up with Senator Negron's intent. And we have met with the senator, and we certainly work on it going forward. So thank you. Sure.
I do have one quick question. You talked about waiving away their right in the don't we allow them to agree to binding arbitration and some of those things and waive the basic constitutional right to the courts?
Well, Madam Chair, you'd be waiving the procedural in terms of the forum in which you're going to bring those claims, but in terms of your the parties' relative liabilities and their need to provide insurance protections, that's what we're focused on here. But as was indicated, as the property owner, in theory, you can sit down with a design firm and negotiate out who's going to have what insurance protection, what the limitations of liability might be. But I think, especially in the context of a small business owner or a homeowner, that's probably not a realistic expectation.
Okay, but we do allow them to go to binding arbitration, and they understand that fully then when they sit down at the contract table.
Frequently, that's the case.
Okay. The next one is Warren Husband with the Florida Associated States. Oh, I'm so sorry. Carrie Hebrank with the Florida Home Builders Association.
Madam Chairman, that Florida Home Builders Association waives in opposition to the measure at this time, and will continue to work with the Senate sponsor.
Okay, waives in opposition. Jason Matson with the Florida Engineering Society, Florida Institute of Consulting Engineers.
Yes, waive and support.
Waives in support. David Daniel with the Florida Surveying and Mapping Society.
Madam Chair, we waive and support. Thank you.
They waive in support. Dana Gillette with the Edmund Anthony Florida Engineers Society.
Yes, waive and support.
Thank you. I apologize if I'm messing up people's names. Gerald Ward.
Terry Ward, yes, waive and support. Thank you.
Okay. Travis Moore, the Community Associations Institute.
Thank you, Madam Chairman, members. The Community Associations Institute generally follows the school of thought where we oppose legislation that would limit your community associations, would limit leave them unprotected and limit the liability against design professionals in those settings. We've provided our comments to the chairman and his staff, and we'll continue to work with him. And our one concern that I would also mention is on the insurance provision. We've been through this before in Chapter 718 when we force-placed insurance on unit owners. The legislature then had to go back and repeal that provision because there just was not a product available for the association or the unit owners to buy. So we just would keep that in mind as well as we work through these issues. Thank you, Madam Chair.
Okay, thank you. Richard Watson with the Associated Builders and Contractors.
Madam Chairman and members of the committee, Rick Watson, ABC of Florida. ABC are commercial contractors. The bill in the present form we oppose. In response to your question, Madam Chair, the procedure for binding arbitration is much different than what this bill does. This bill limits the liability of individual engineers and architects. For large commercial construction projects, that's not really an issue because you have big jobs, sophisticated people dealing with lawyers and financiers. The impact of this bill would be felt on small commercial work and on residential work, where it is changing the immunity law, the tort law, for professionals. Engineers, doctors, lawyers are considered professionals, and they're held to a higher standard of care. It pains me to speak against the bill because normally the contractors and the design professionals work hand in glove. We need them, they need us. But in this instance, we're looking ahead to situations where a project goes bad, and they do occasionally. Everybody gets sued. And you're taking the individual professional who might be responsible for it out of the mix. And we don't think that's good public policy. We're working with the sponsor, as mentioned before. When you take rights away, they normally are replaced by something. We're talking about mandatory liability insurance for the firms. When this bill came up a couple of years ago, we tried to do the same thing, but were unsuccessful because the design professionals and the construction industry had a difference of opinion about what liability amounts were reasonable. So professionals may have 10 or 15 projects, and so any insurance policy that was low in number would quickly be eaten up if you had problems. So we'll continue to work with the sponsor, but in the present form, we regrettably oppose the bill.
Okay. Next is Eli Nordalis with the American Society of Interior Designers. Waves in support. Okay, we have Richard Monticello from Terracon. Oh, sorry, I apologize. Waves in support. Okay, and lastly, we have Mike Huey with the Florida Association of American Institute of Architects.
Thank you, Madam Chairwoman. Thank you, committee, for hearing this bill. My name is Mike Huey. I represent the Florida Association of the American Institute of Architects. I've been a construction lawyer for several decades. And I've been through the whole Marantz opinion and have kind of lived with this issue representing both architects, owners, engineering companies throughout my practice. If I will be honest with you, if the architects had their druthers, you would have a bill here in front of you that would say that architects, their employees would be treated like the other employees on a construction project, where they're not exposed to liability if their contract's in existence, which is the way that the law was prior to the Marantz decision, and which is the way the law has been firmly established in Indiana and Arizona by their Supreme Courts. What Senate Bill 286 does, at least, is allow the owners of projects who want to hire architects and engineers for those two parties to have a discussion about this issue going into the contract, where the architect can say, we would ask that you would consider waiving any claim you would have to go after any of our employees if we have a dispute down the road. Now, they can't force, I've seen some literature put out that came to you that would imply that all they have to do is write it in their contract and the owner's got to agree with it, but that's not what this bill does. What the advantage of that is it allows at least the design community to know going into the contract whether or not their employees are going to be, their professional employees are going to be at risk, continuing risk, should something go south on the project. And we think that's a good thing. Now, with regard to our contractor friends, because they are friends of ours, and we work side by side with them in construction work. And most all of them are we're working side by side with people who are equally educated out of the building trades school at the University of Florida somewhere, as are our architects who graduate from the University of Florida or other colleges. So they're equally educated, if that's supposed to be the test of who should be personally liable or not. But the fact of the matter is, their employees are never at risk under their contracts. They are never at risk. Their subcontractor employees are never at risk for business damages, and this is all this relates to. So at least this bill allows us to address on the front end whether or not that should be the case for architects and engineers and their employees. I will also tell you, with regard to the issue of will homeowners understand these provisions, and I thought the chairwoman raised an interesting point, because I've been in this business a long time and I know that homeowners sign arbitration provisions all the time that are given to them by general contractors. And I guess their position is they clearly understand what they're waiving in those, but they wouldn't understand in bold print if it's stated in the contract that you will not seek to go after any employees in the firm. So we think that the sponsor has done an excellent job of considering the viewpoints of all parties, and it's come down probably not exactly where we would have liked it to come down, but have come down in the middle of somewhere which makes some good public policy and at least gives us the opportunity at the front end to know whether or not the project is going to proceed with our employees being exposed for liability. I'll be glad to answer any questions. Thank you.
Thank you very much for your time. And what I thought was the last appearance card, evidently we had a late filed appearance card from Brian Pitts. So Brian Pitts, you're recognized.
Understand, I love you all. I got nothing against you, love you, everything. No, seriously, but I mean, when you see an issue, it is your particular view, but I try to come absolute on issue. Brian Pitts, Justice Deeds, this bill did come up before, regulated industries in the past. It was pretty brutal last time because they did strike it down, I'll be honest. Here we are again. Okay, I'm going to stay in the purview of this bill as it is and not go into areas of judiciary. When you go into business, there are costs associated with that. And you understand there are losses when. Now, these professions that are mentioned here, they have to be very careful, or maybe you shouldn't be in the business. Now, they want to have some scapegoats for themselves and their agents and employees and trickle on down to contractors if they could do that to where, okay, we don't want to be liable for everything, but we still want to do your work. So we can mess up. And with this new bill, we know we limit it. Don't even give them the thought. Don't get in the business then. Every profession has to deal with some relapse or some recourse if they make a mistake. We're human beings. But you think about that when you're in the trade, whether you want to get involved in it or not, and understand, am I willing to take this loss? Do I know what I'm getting involved in this particular trade or business? Don't come to a government agency as a profession and now want perks, and it's something you decide to get involved in. And you know, in this particular case of the trade, let the profession or the practitioner beware. Because what you get involved in may get you may lose your shirt. Well, I guess they tired of losing their shirt, so they want to come to government and says, okay, we want to limit a shirt and help employees out and agents and everything. That's not how it flow. Then get out the business. You should not be here today trying to deregulate for them how they cannot be sued in court because of negligence that they commit. The courts have ruled, and the courts have ruled very difficultly in different cases on the economic loss rule and the issues connected with the negligence and everything. From contract going back and forth to tort, contract, tort. Even I'm not happy with it, okay? But nevertheless, they try. It is an affection to where you can predict what it is. Leave it like it is. They're the custodians of negligence anyway. It's a creature. That's a creature created by the court from the common law. Don't mess with this using statutory language. Leave the way it is until we have some major problems. The consumer, they thinking this is a profession. I'm not expecting you to give me a lemon house or a lemon design or lemon. I'm not expecting this from you. And now here it is now. I'm very limited of how I can pursue you. And I thought you was a profession. I put my confidence in you. I put my credibility in you. And how do I know you did it in purpose? Because you know you probably can get away with it. Because now you know your loss is very limited. No. Don't get into business practitioners in the room and who's listening. Research what you're getting into. Think about it. You may not want to get into the trade. You do something else. You should not be regulating this, and I'm sorry, it should not be supported. I understand their concerns. It should not be supported. Thank you.
Thank you for your thoughts. Okay, now is there any debate on the bill? Okay. Sure, you can ask a question. This one.
I think I actually have two questions, if you don't mind, Madam Chair. If one is a single or sole proprietor architect, how does this bill affect that person? There's just the one person in the firm, if you will. How does that work?
Madam Chair, the same way it would, regardless of how the business organization is formed, you would have a claim with all the rights and remedies against the sole proprietorship, just as you would against the association or a limited liability company or whatever entity it was. And by the way, if the bill did what Brian Pitts said, I would not be supporting it and wouldn't have filed it. And by the way, I agree with almost everything he said about if you go into a line of work, you have to be accountable. We're not taking away your rights. What we're saying is you can sue let's say I'm making up a name. It's ABC Architectural Firm. That's who you hired. If they mess up your house and it's crooked and you got to redo it, you can sue them. Let's hope they have malpractice insurance, and you can have your claim. What you can't do is one of the 10 architects that worked on it, you're going to sue them personally and require them to get their own attorney and have this harassment is what I think is mostly used for. You still have every claim against the entity that you hired. You just don't have individual personal liability against any employee that worked on the job.
I think you answered my second question in the second half of what you said. But so just let me do a hypothetical.
Okay.
I have my architect firm and I have 10 people working. That would be nice, wouldn't it?
That would be good. That'd be especially today.
and
you'd be the largest architectural firm in Tallahassee, probably.
The state. And so without your bill, even though the individuals work for my company, each one would need to carry their own liability insurance in order to protect themselves once they did the work, if they got sued, and my company got sued, and then I got sued personally too. Is that what?
No, Senator Gibson. Actually, your concern is what I'm trying to address in the bill. I don't want individual members of the architectural firm to have to worry about being sued personally because they're in the course and scope of their employment. They're working for the company, so the company should be responsible. But what I'm trying to stop is exactly what you just said, so that each individual person who's going to work and doing their job, if they make a mistake, there should be accountability. And the accountability is for the entity that was hired to do the work, but each individual person can't be sued individually. But your rights against who you hired are 100% protected and they're not affected in any way. I just don't think you should get in the habit of suing individual employees who work for a design firm. I don't see what's accomplished by it other than to shake everyone up, require people to hire their own personal attorneys. The real world is that when these cases are brought, they're based on coverage, and the coverage is with the firm, and so I think that provides an adequate remedy.
I'm sure. Are we in?
You can ask questions if you like.
I don't have
we
a question.
Have a lot of
I'm
okay.
ready to debate if you are.
Okay, we'll move on to debate. Senator Thrasher.
And I want to support the bill, and I'm going to. And the one, nice to hear from all of our friends out there who live in Tallahassee and represent all these different organizations. But probably like you all, maybe a bunch of you got some notes from different people around the state. And this is one that was moved me, and it's very consistent with what Senator Negron said about the bill and what it does. And this is from an owner of a company it's a 40-year-old engineering practice, He said been struggling to stay afloat. I think that's probably right in the economic conditions, and he's urging our support. And here's his reasons. He said legal liability is a major concern to any business offering professional services, and the cost of liability insurance, it takes a big bite out of our income. Nevertheless, I accept the risk and the cost as an owner of the business. However, it's unjust to place the professional employees of my business at personal financial risk. This bill allows me to subject to agreement by my client and subject to maintaining adequate liability coverage to protect my employees from personal liability. I think that's good public policy. I think that's great public policy. And I think it's going to help maybe these engineering firms get a little bit more business, hopefully take a little bit more take-home pay, hopefully hire a few more employees, and do the things that they're trained to do. So, and then he goes on to point out all the protections that are in the bill that Senator Negron has placed in the bill that I'm sure some people probably would disagree with, who even support the bill because he's gone so far to protect folks who are in these contractual relationships. I think it's a good bill. It's worthy of support, and it's hopefully going to increase the opportunities for our engineering professionals to do their work and do it without the risk of personal liability. So I think it's a good bill. I look forward to supporting it.
Thank you, Madam Chair. Last year, I think I sat on Regulated Industries and I voted against the bill. But, the protections that I think that Senator Negron has put in now, making sure that it's in the contract, making sure that it's bigger print, so it's not something that can be caught in the fine print, give me a little bit more comfort with the bill this year, and I thank him for moving in this direction and allowing me to be able to support this bill this year.
Senator Galvano.
Thank you, Madam Chair, and I would just emphasize one other point with regard to it being a contractual provision. There was some testimony today about somehow people to the contract were not going to be adequately protected. Once that provision is in the contract, it is still subject to all the contractual defenses that exist in law today: fraud and inducement, misrepresentation, undue influence, unconscionability. And so just because it's in the contract, if it doesn't pass contractual muster, it won't be enforced. So ultimately, all we're really doing is giving the freedom to contract between parties to limit liability for the individual within the firm versus removing a class of liability.
Thank you. I couldn't have said it any better than the lawyer, so I'll Representative, I apologize. Senator Negron.
I like being a representative. It was good. Thank you, and I think the comments that were made, Senator Brandon, thank you very much. That means a lot. I think, I err on the side of people having the right to access to court, people having their constitutional rights. I just have not heard a compelling argument on, just as it said in that letter that Senator Thrasher shared with us, the company is responsible. You hired a company. If someone's out of the scope of their employment, let's say somebody in the company is meeting you at Taco Bell and wants to do your work for you, they don't get protected here. But when you hire a company, I think most Americans expect the company should be there to be responsible. And I just think the practice of having design professionals worry that in every single case they work on, they can be sued personally, have all of their assets at risk. I don't think that serves any purpose other than to try to give leverage to one side. So, and Senator Thrasher, you alluded to it because you've been doing this a long time and you pick up on these nuances. The engineers and the architects probably wish they'd gotten a different bill sponsor, because I think they are professionals. I think they're different than contractors. I think engineers and architects, that is a select group of people. They're professionals, and they should be held to a higher standard. And it's not a matter of rating the value of any individual occupation, but I think they are held to a higher standard, and they should be responsible for their negligence. But it should be done through the business, especially when we have a provision that says to everyone, looking to the business if there's a problem, and we shouldn't be suing individuals when they're acting in the course and scope of their employment. So thank you, Madam Chair, and again, I apologize. I was over-presenting another bill and got here as quickly as possible.
It's quite all right. Will the administrative assistant please call the roll on the passage of Senate Bill 286?
Senator Dietert, Senator Flores, Senator Galvano, Senator Gibson, Senator Legg, Senator Sachs, Senator Sobel, Senator Thrasher, Senator Brannan, and Madam Chair.
Yes. So by your vote, Senate Bill 286 is reported out favorably.
Thank you, Madam Chair. Appreciate it.
And with no other business before the committee, Senator Galvano moves you rise.